Welcome, everyone, on this beautiful fall day in Vermont for the third Law Review Symposium, Safeguarding Tomorrow. Focus today is going to be on LGBTQ youth. We truly have a stellar panel of experts in the field. It's really quite remarkable when it comes time for me to offer their bios and information. First, I'll just offer some words of introduction. I am Greg Johnson, for those of you who don't know me. I've been teaching at the law school since 1997, and that was the first year I taught sexual orientation in the law, and I've been teaching it ever since. The book we use has gone through many editions, but I still have the one we used back in 1997 on my shelf, and it's instructive to look through that because there's not much to cheer about. And so as we today talk about the challenges we face now, it is important to appreciate just how far we came. Because in 1997, Bowers v. Hardwick was still good law. This means that states could criminalize the expression of our identity to the tune of 20 years in jail. That was the penalty in the Georgia law that was upheld in that case for private, consensual intimacy between adults in their bedroom, 20 years in prison. There were no protections at the federal level for employment discrimination, and only a handful of states offered such protections. By the way, that included Vermont. Vermont extended protections against discrimination based on sexual orientation, but not gender identity, in 1992, making it the fourth state to do so. Marriage equality was just a fantasy, some absolute unrealistic dream, never going to happen. In fact, what's instructive is that most of the debate back then was within the community, trying to convince the community to support marriage equality, because the community had different values and different priorities. Family law was a disaster. Gay people who were in heterosexual marriages were treated terribly by courts, losing custody and even visitation with their own children. The most popularly cited law review article at the time was Rhonda Rivera's "Are Straight-Laced Judges the Legal Position of Homosexual Persons in the United States?" If you want to see what life was like in the United States in the 1980s and 90s, read that article. Gays in the military? Forget about it. Wasn't going to happen. But see, we persisted. The community was resilient, and we wouldn't take no for an answer. And throughout it all, one of the vanguards of the movement was the queer youth community. Early victories, the ones that established an anchor for which we could build, were actually created by queer youth, both statutorily and through the Constitution. Aaron Frick, in 1980, all he wanted to do was bring his boyfriend to prom. That led to a national controversy and, in fact, a great First Amendment case on the freedom of speech. As well, statutorily, queer groups in high schools used the Equal Access Act, a federal law, to gain status for gay-straight alliances in schools when schools didn't want to recognize them. And then at the college level, groups across the country effectively used the First Amendment's freedom of association to gain recognition. There's an important case actually out of the University of New Hampshire, and the next state over, in the First Circuit, and then one from the Eighth Circuit with the University of Missouri. In that case, gay lib won, and the court ruled you had to recognize them. The University of Missouri was not happy with just a defeat at the Eighth Circuit. They appealed all the way to the Supreme Court. The Supreme Court did not grant cert, but Chief Justice Rehnquist dissented and said he thought the court should hear the case. And I've kept count, he's no longer with us, but Chief Justice Rehnquist had a perfect record, 100%, every opportunity ruled against gay people, clean straight on through. And in this case, he likened the desire of queer people at the University of Missouri to gather to argue for reform of sodomy laws. He said that would be like allowing people with measles to gather together to argue for reform of quarantine laws. That's how he saw the movement. But the students won that case. So we persisted and we prevailed because our cause was righteous and just. And by the 2010s, we were seeing cases like Obergefell and Bostock, and it seemed like victory was at hand. And in fact, that's the name of a book, popular book that came out after the Obergefell case, talking about how we got to that point where it went from impossible dream to reality. And that book was called Victory, complete with an exclamation point, victory. I think to myself that if the author were to write a sequel, it would be called Not So Fast, because things have changed rather dramatically, haven't they? From that time when the White House was in the rainbow flag colors to now where Justices Alito and Thomas openly call for the repeal or the overturning of Obergefell. And that's two. You only need three more. And see, they know that the life of jurisprudence is long, and with three more, it would go the same way as Roe v. Wade. And as you also all know, there's just a legion of new laws across states. States are falling over themselves to pass laws discriminating against trans people, and in particular, trans youth. And that's going to be the subject of this panel. Above it all, of course, lies the Scrimeti case, and that's where the court this term is going to ask whether it's constitutionally allowed to ban gender-affirming care for minors. But there are many, many other ways that states are discriminating against trans youth, whether it's sports, bathrooms, pronouns, and it's not even just trans youth. States are now trying to discriminate against gender treatment for trans adults. So the community is under attack, and this panel is how we fight back. So I would like to introduce our panelists. First off, this is going to be quite a treat. The Law Review, and let me thank the Law Review, by the way, for this first, not just this panel, but the wonderful series of panels. I really, again, I've been here that long, I can't recall the Law Review having such an extensive series of great panels with fantastic speakers. So I really want to thank the entire Law Review. I also want to thank, I know I'm going to forget names, but Isabella, Lyndall, Charlotte, Mel, all the people who, in particular for this panel, work with us here up on the podium to make this a reality. So I really want to thank the Law Review for this tremendous series of panels for the symposium. And I also, by means of one announcement, want to say that the Law Review will be sponsoring a cookies and coffee session right after this panel at Barristers. So the way this panel is going to work is each panelist will give a 15-minute presentation. We have a few facilitated questions from the Law Review staff editors, and then we will open it up to questions from the audience. All that's pretty much going to take all of our time. If you want a more intimate setting where you can ask one-on-one questions with the panelists, they'll be over at Barristers right afterwards for coffee and cookies. I'll be in class, actually, as maybe many of you will too. But what I was about to say is we have a treat to start with because the Law Review asked for a student presenter to get us started. And Sonia Zhivsky will give a presentation. She wrote a paper in one of my courses last year on trans youth with a very personal story embedded within it. So we're going to open this, the event with Sonia's presentation. Following that, right in the order you see them, Professor Greta LaFleur will speak. Professor LaFleur is an associate professor of American Studies and Women's, Gender, and Sexuality Studies at Yale University. Their research and teaching interests include early North American literary and cultural studies, the history of science, the history of race, the historiography of sexuality, and queer and trans studies. LaFleur's first book, The Natural History of Sexuality in Early America, explores the connections between 18th century race science and the emerging science of sex in the colonial Atlantic world. Professor LaFleur has edited several collections, including Transhistorical, Gender Plurality Before the Modern. They have also edited special issues for journals such as American Quarterly, Transgender Studies Quarterly, and the GLQ. Professor LaFleur holds a PhD from the University of Pennsylvania and a JD from the University of Connecticut. Joseph Wardensky, now you'd have to be, most of you probably weren't around, but this is actually the second time that Joe has honored us with his presence and his expertise. We had a great 50th Stonewall celebration up in Burlington, and Joe came for that. Joseph Wardensky is the founder and principal attorney of Wardensky PC, established in 2021. A distinguished civil rights lawyer, Joe has extensive experience litigating complex and groundbreaking civil rights cases nationwide. At Wardensky, he represents individuals and organizations challenging discrimination in education, healthcare, housing, and voting, and consults with various entities on civil rights legal strategy and compliance. Before founding his firm, Joe litigated civil rights cases at the New York State Office of the Attorney General and with the United States Department of Justice Civil Rights Division. At DOJ, he co-chaired the Civil Rights Division's LGBTI working group and contributed to significant Title IX investigations. Joe was lead counsel in several landmark transgender rights cases. Following Joe, Cynthia Weaver will speak. Cynthia is the Senior Director of Litigation at the Human Rights Campaign. I'm sure it's an organization many of you are familiar with, the largest LGBTQ+ civil rights advocacy organization in the United States. Previously, she was a senior counsel at the New York City Law Department's Impact Litigation Unit, where she served as general counsel for the New York City Task Force on Racial Inclusion and Equity. As a senior staff attorney at Manhattan Legal Services in the LGBTQ HIV Law Unit, Cynthia litigated a case of first impression against a federal housing agency. Cynthia has also served on the advisory committee of language access for the New York State Unified School System. Cynthia holds a BA in philosophy from Rutgers University, a Master of Science in Human Rights and International Politics from the University of Glasgow, and a JD from City University of New York School of Law. After graduating from law school, Cynthia clerked for the Honorable Christian F. Hummel in the Northern District of New York. Rounding out our presentations will be Danielle Danny King. Danny King is the Senior Youth Policy Counsel at the National Center for Lesbian Rights. Prior to joining NCLR, Danielle Danny served as staff attorney in the Community Justice Unit at the Legal Aid Society. Danielle Danny also represented youth in abuse, neglect, and juvenile delinquency proceedings as an attorney for the child in the Juvenile Rights Practice Division. Danielle Danny has conducted numerous CLE trainings on issues facing LGBTQ youth and the disproportionate impact on BIPOC children and families in the legal system. From 2020 to 23, they co-chaired the New York City Bar Association LGBTQ Rights Committee. Danielle Danny holds a JD from Seton Hall Law School and an MA in Urban Affairs from City University of New York Queens College, and a BA in English from Michigan State. And here's Sonia's bio, a wonderful one, is a graduate of New York University and is currently in her last year of law school at VLGS with a concentration in energy and international climate change law. She also spends her time as a journalist and senior editor for The Jurist, a legal news publication, and writes regularly about justice, international human rights, and the United States civil rights laws. So please welcome Sonia for our first presentation.
Thank you so much, Professor Johnson, and I'm honored to be here. Oh, was that the clicker?
Yeah,
Oh, super.
Yeah.
Okay, great. Let's see if I can manage. Good afternoon, everyone. Last summer, I wrote a paper titled "The Constitutional Implications of Anti-Trans Laws Affecting Children's Access to Medical Care: A Parent's Fundamental Rights Perspective." I addressed a parent's fundamental right to parent and their recognized freedoms and liberties when raising and making decisions for their children. These rights are inherent and protected by 100 years of Supreme Court decisions. Being here with this panel of experts in their field, I think my contribution today is best served by giving a little bit of a backstage view of why I wrote this paper. You see, I am a very proud auntie of a wonderful 6-year-old that we will call Jay. Jay has strongly expressed gender fluidity since they began speaking, and has done so clearly and consistently. We, as a family, love and support them fiercely. Today, I am assured that in Brooklyn, my brother's child can dance at the Shining Star Ballet School and wear the most sparkled pink tutu that they would like, despite the gender they were assigned at birth. In this vibrant neighborhood of recent New Yorkers from Bangladesh, Iran, Russia, Ukraine, Wisconsin, Jay and I, just this past June, were wandering down the street and found a little bookshop called the Lofty Pigeon Bookshop. We came inside, and lo and behold, it was story hour for children, and the book being read was The Night Before Pride, read by their author. So Jay is living in a wonderfully fantastic neighborhood, and when Jay isn't performing or isn't in their first grade gifted, and the whole family was debating and quite excited about the prospect of this position, except for one thing that changed everything. Let's see. A law passed last summer in Texas prohibiting transgender kids from getting the gender-affirming care that doctors recommend. The state has one of the largest trans communities in the United States. Therefore, advocacy groups say that the law affects an estimated 29,800 youth under the age of 17. The medical community in Texas overwhelmingly opposes the new law. But unfortunately, as we all know here, this law is not an anomaly, but a part of a dangerous wave of discriminatory legislation. I believe the anti-transgender laws are indeed a 14th Amendment issue for children, but also significantly target a parent's fundamental right because the parents are being treated differently from parents of a cisgender child. Additionally, the anti-transgender laws interfere with a parent's right to privacy regarding medical care decisions. Transgender people have been a part of and always have been an integral part of humanity. In my research, I found that the application of transgender is illuminating in many different cultures through language as they embrace and celebrate the non-binary. I may not pronounce all of these words correctly, I'll do my best. The Farafine and the Faratama is Samoan for gender that moves between the male and female worlds. Waria and Warita is Indonesian for the sacred unity of both. Hijras is Hindi for gender that is spiritually powerful. The Mahu is the third and fourth gender in Hawaiian culture and are so revered that they're often asked to help a family name a child. Two-spirit is a term to help explain, perhaps, to the rest of the world. Northern American indigenous tribes may have up to 12 or more different ways of explaining gender. In the United States, people of the transgender community have not asked to be in a revered position, but only to have equal rights and to live without the fear of persecution. So, a little about the legal rights of my brother and his wife, the parents of Jay. Case law already defines a parent's right to, for example, teach their children a foreign language, to choose between private or public school education. If you want to play softball with a nun, right? That's okay. To express religious beliefs. For a widower to have custody of his own children. To make decisions about mental and physical health. To raise a child in an interracial family. And we as a society presume equal rights exist for all parents, regardless of the race, sex, ability, or gender identity of their child. The Egyptian Heika Haku is considered a healer that lives without duality. This Egyptian healer not only transcended dualities and binary gender, but the Greeks later took this to be a symbol, and a well-revered symbol, known as the staff emblem for medicine and healing. So the non-binary Heika's influence and wisdom has been with us globally for thousands of years. Now, I might need a little help with this last one. It's a video that ideally with internet, okay, maybe not.
Brian's got it.
Sorry? Oh, there we go. Great, thanks.
If you passed me on the street,
Or in a restaurant.
Or on a plane.
Would you think that I was kind?
Would you wonder if I was extraordinary?
or if I might dream of changing the world.
Because if I saw you on the street,
Or in a park?
I might wonder how you became the person that you are.
Are you an author, an athlete, or studying to become a doctor?
Do you dream of moving mountains with your words? Or building bridges with your heart?
Have you ever performed in front of a crowd?
introduce the President of the United States.
Or inspired people to be themselves and follow their dreams?
When you imagine the life that you want to build,
It's probably pretty close to the life.
That I want to build.
It's probably pretty close to the life that we all want to build. And even if I don't yet understand how you became you,
Or how brave you had to be.
Or how many times you had to take a deep breath.
and know that you were just one step away from showing the world how incredible you are.
I do know this. If I passed you on the street, and if we started talking,
I would listen.
I would learn.
And I would accept you for who you truly are.
even if the world isn't always the place we want it to be,
We are always the ones who can change it
we just have to listen.
Respect one another.
and decide.
That today is the day that
Everything changes.
So I'm grateful that when Jay gets a little older, this group is available for her. And I also believe it is unequivocal that the United States Constitution supports a world where my Jay can fulfill their dreams like any other American. Thank you.
One thing I forgot to mention, I'm going to turn the event over to Danny King, and they've got a series of poll questions. We thought it would be helpful to poll the audience, so this is going to be a little interactive exercise just to suss out your understanding of the issues we're going to be talking about. So take it away.
Yeah, hey everyone. I like stuff to be at least somewhat participatory, even in a big space. So if you've never used Slido before, you just go to the website. It's slido.com. And the code, the participant code is up there. I'll say it also in case you can't see it. And I'll give folks a second to pull up the website. You don't have to download anything. Once you go to the website, you enter the code, and you should see the first question launched. And so pretty much what we're going to do is it's just going to be 6 questions, but just to kind of gauge some of your understanding, and we're going to go into more detail into some of the poll question topics, but just to kind of get an idea of the room and folks' understanding of LGBTQ youth. So if you can't see from up there, the poll code is 844-8111. Again, the poll code is 844-8111. I feel like I'm like reciting bingo or something, like B11.
Got my stamp card.
All right, I see a few people have done it so far. Yeah, it's 844-8111. I know some folks might not be able to see the screen. I didn't put a timer on the first question because I figured it takes folks a little while to get on. Give them like another minute. So give folks a few more seconds. Looks like 50 people voted so far. That's great.
Good tally. That's good.
Yeah.
Thanks for participating.
Looks like most people may have done it. Haven't seen any new vote in a second. So I'm gonna lock it. Okay, so the question was, in case you weren't able to pull it up on your device, children typically begin to understand or become aware of their sexual orientation around what age? And the options were 8 years old, 10 years old, and 12 years old. So the average age that young folks become aware of their sexual orientation. So it looks like most folks thought the answer was 70%. 8 years old was 70%, and 10 years old, 29%, 12 years old, 2%. So I'm going to reveal the answer if you still have it up on your device. So the answer is 10 years old. So that's the average age, from the most recent studies that folks say that young people become aware of their sexual orientation. And so what many of you probably may know, but especially when I give these presentations to different audiences, I just emphasize, and the same with the next question, that this is average age, right? So this doesn't mean that, you shouldn't talk to young people that are younger than 10 years old about their sexual orientation, or that they may not want to have these conversations with you. This is just an understanding that a lot of folks sometimes think that young people don't start thinking of this until they're like in high school and dating age. And what most of us know is that you start thinking about like attraction and, intimacy a lot younger than that. And so, and when I was representing young folks in family court, I had clients that, were young as, 5, 6, 7, 8. I know myself, I knew when I was 5. So it's just important to understand that this is like, an average, but not, the benchmark litmus test. And for folks who, represent young people, I think it's, really important to not assume when you can have these conversations, and just start to have these conversations in your advocacy so you can know who your client is. And I'm going to move to the next question. It should pop up on your device automatically. And if someone has an issue, you could raise your hand, and I can pause the poll if you have a problem. All right, so it ended there. Folks were a little bit faster this time. So the second question was, at what age do children typically become aware of their gender identity? So most of the audience said 5 to 7 years old, around 63%. 25% said 2 to 5 years old, and 12% said 8 to 10 years old. And so I'm going to reveal the answer. So 2 to 4 years old is when children typically become aware. And so emphasis here is aware, right? That doesn't mean that they have a full understanding. I'm still understanding my gender identity as a trans non-binary person every day, right? But when do they start to become aware of themselves, their body, the world, how the world sees them, how they want the world to see them? And so a lot of young people start to understand that on average, very young, as, toddlers. And if you have kids, or you mentioned, nieces and nephews, you see little kids and the things that they want to pick out and what they want to wear and how they want to express themselves and the things that they want to do. That's when they really start to understand who they are. And they may not have a full understanding of it, but that's when they kind of become aware of those things. And so, it's always interesting, because I feel like for this question, a lot of folks usually are very surprised to see it, so young. And that's because, I think that there's certain biases there that you wouldn't have this understanding, at that young of an age. And it's just not true. If you can understand a young kid wanting to wear tutus and dance around, if they're a cisgender girl, you should understand that if a child doesn't feel that they identify with their, sex assigned at birth, that they can know that also at that same age, and so I think it's just important. Again, it's not a benchmark. Some folks may not even become aware of it, in elementary or high school years or later in life. But on average, most young folks do start to become aware of it at a young age. And now what they do with that information as they get older, will, change over time. And it's different for each person's journey. But just to understand that, young folks do have this awareness very young. And I just lost the next question. It's going to lock in one. All right. Just to kind of move us along, the next questions lock a little bit more quickly. So that question was, what percentage of youth in foster care identify as LGBTQ+? And I'm going to go a little bit over it more in my presentation, but I'm going to reveal the answer. So it looks like it kind of was split. The answer is 30.4%, but it looks like about 44% of folks had that answer, and 45 thought it was 20.5%. And 11% thought it was 10.7%. And just the importance of this statistic is like almost a third on average, and this is like a national statistic of young folks in foster care identify as LGBTQ. So if you are thinking about working with like youth in the foster care system, this is super important for you to know and understand the needs of LGBTQ young folks, because that's a huge population of young folks you might work with. And, you know, in my practice, sometimes I've noticed, I don't want to like call out older attorneys, but folks who were not, you know, as aware and trained, a lot of times they didn't have conversations with young folks about their sexual orientation, gender identity, so they just assumed their clients weren't, and they didn't identify as such. And so they were like, it's not that big of a percentage, I don't see it. But a lot of times young folks may not let their attorneys or caseworkers, social workers, a lot of folks in their lives know how they identify. Maybe they only tell their friends, maybe they're not out yet. But on average nationally, in some places like New York is a little higher, 30.4% is the average percentage for LGBTQ youth in foster care. I'm gonna move right along to the next question. And that question is going to lock in 2, 1, now. Okay. So again, this one looks a little split. So the question was, how many LGBTQ plus youth are involved in the juvenile justice system? And so most folks were between 20% and 40%, 20% getting 47% average and 40% getting 42. I'm going to reveal the answer. So the answer is 20%. So about 1 in 5 youth in the juvenile justice system identify as LGBTQ+. And when you look at girls in the juvenile justice system, those numbers are even higher. So again, you know, a significant amount of young folks in the juvenile justice system are LGBTQ. So if you're working in these settings, it's imperative that you know the needs, and especially as young folks that are like incarcerated and removed away from their families and their communities, they have specific, you know, needs, and especially when it comes to medical care and things like that I'll talk about more. So it's extremely important that as advocates, you think about that and are aware of those things, because you may be the only voice that can advocate for them, you know, because a lot of times when they're, especially if they're locked in facilities, you know, requests that they may make may go on deaf ears. And so especially when you're representing young folks, if they are incarcerated, there's, you know, particular concerns and things you should think about. And just launch the next question. And that's number 5, so only one more after this. So that's like the whole time now. All right, so that question just locked. And so that question was, minor children can receive hormone therapy to treat gender dysphoria before they reach puberty. And so 57% said false and 43% said true. I'm going to reveal the answer, and then Cynthia's going to talk more about that question.
I don't know why I drafted true and false questions, because I hate them. But it is, I just want to be clear in the room here, at least, that people know that you know, children don't get on any treatment before puberty, right? When they They're monitored for when they reach puberty, then they can get blocking medication if it's medically necessary at that point. And then they're monitored through that process for a year to 3 years. And then if it's appropriate, they may get hormone treatment. I just want to set a baseline for the room.
Yeah, especially with a lot of the misinformation out there.
Absolutely.
So we're going to move to the last question. All right, so it looks like that's done. So the question was, mental health providers in the U.S. can provide talk therapy to change an adolescent's gender identity or sexual orientation. And so it looks like most folks said depends, which was 63%. 33% said no, and 4% said yes. I'm going to reveal the answer, which is depends. And
yes, it depends. It depends on which state you live in. But it is not, conversion therapy, reparative therapy, SOGI, change efforts is not banned in every state in the U.S. In fact, in Indiana, the state had banned localities from banning that type of quote-unquote treatment.
Thank you very much for the polls. And Professor LaFleur, you're up first.
Okay. Sorry, just give me 1 sec to set my timer here, just to keep myself on track. Okay, good morning, or actually barely afternoon, everyone. I want to thank the many people who made this symposium happen today. So from the organizers, the IT workers, the catering workers, my co-panelists, and all of you. And also offer special thanks to the organizers of this symposium, Charlotte Bieri, Isabella Pickett, and Lindell Gudemon for inviting me. While I am a practicing attorney, the work I'm here today to present on derives from my scholarship as a cultural historian of gender and sexuality in North America. Now, while I was trained as a colonial Americanist, as a gender and sexuality studies scholar, the politics of the present have always constituted an important perspective on, and at times a driving factor of, in the development of the kinds of questions I've asked about the past. So for today's panel then, I want to offer a little historical framing on the question of LGBTQIA children and minors, how gender-affirming care has been regulated in the past, and how to think about attacks on trans children or minors in our own moment. And I want to say something else, which I was just thinking of as I was listening to Professor Johnson introduce the panel. I myself was at one point a queer youth. Now I'm a queer middle-aged. But I like that kind of organizing. I was part of a project called Project 10 East, based in Boston. As a teenager in the 90s, I started a GSA. My one legal claim to fame is that there was such a repressive response to us starting our GSA in our public high school in Massachusetts that Mary Bonato, who I believe works for GLAAD still, who ended up working, I believe, on Obergefell, actually visited me and my co-GSA founder when we were teenagers, bought us pizza, and I know retrospectively that she was shopping for test cases. We were not it. But I did appreciate the pizza. At the time, I was like, why are you asking us these questions? But just to say, queer youth grow up to be queer adults most of the time. So it's sort of, that's the kind of perspective that I'm bringing here today. So, I wanted to, I'm going to start kind of basic and then sort of open up. And, my job on this panel is to really think about some of these questions in sort of historical and more theoretical terms. So I'm not going to limit what I say here today sort of exclusively to work on the law. So first I want to just move to a problem and quickly dispense with hopefully a problem that I think has characterized a lot of the ways that attacks on gender-affirming care have sort of transpired. And that's by painting gender-affirming care itself and also trans or gender non-conforming kids as or minors as like new or novelties, or like there's like it's this sort of new phenomenon. So I'm sure that many of you in the audience, if not all of you, will be familiar with the phenomenon I'm describing here, but it's so important to name that I nonetheless feel that I need to address it. So this phenomenon is the painting of queerness, and especially transness, and especially queerness and transness of children and minors as new, novel, a phenomenon endemic to the 21st century, or at oldest, the late 20th. So before I debunk this reality with actual historical sources, of which there are many, and that this is something that proponents of gender-affirming care bans, book bans, don't say gay laws are generally kind of loath to explore, I want to just talk quickly about the ideological character of this newness, of this idea of newness. This idea and this critique is hardly a new idea in and of itself, but for anyone who's recently arrived to these conversations, painting queerness or transness, or especially the queerness or transness in children in particular, as new or as a recent form of human experience, is often organized into an effort to delegitimize the experience. So it's hard to argue with social forms that seem transhistorical in character. I think we can think of a lot of examples of that. So masculinity or femininity, for example, like the idea that your like girl-assigned child might want to play with dolls or wear dresses, right? This is something that's sort of posited as a transhistorical reality, even as that is not also itself a transhistorical reality. But a lack of historicity is a tried and true method of attacking the legitimacy of some forms of human experience. And furthermore, it's a form of attack that's increasingly enshrined within the law itself. So think, for example, about the brand new interpretive doctrine of, quote, deeply rooted in this nation's history and tradition that the United States Supreme Court has held out as the barometer for adjudicating substantive rights under the 14th Amendment. So this interpretive doctrine openly uses historicity as a tool to police the legitimacy of claims to rights and protections, which often implicitly also becomes a means of policing the legitimacy of forms of human experience themselves. Consider, for example, and this is not directly in relation to queer or trans kids, but I'll get there, Justice Alito's dissent in Bostock, where, incorrectly citing my wonderful colleague Joanne Meyrowitz's book, How Sex Changed, Alito uses the 20th century provenance of the terms gender identity and transgender to argue that even 60 years ago, quote, Americans in 1964 would have been bewildered to hear that this law, so Title VII in this case, also forbids discrimination on the basis of transgender status or gender identity, terms that would have left people at the time scratching their heads, end quote. So Alito's statement implies that if the average citizen wouldn't have recognized these terms and positionalities, then there is something illegitimate, trite, or inappropriate about carving out protections for them in the law. What this statement occludes, of course, is that by 1964, there had been a groundswell of political organizing by trans people of all stripes across the United States, also across the world, but I'm just here talking about the US. So this semester, I'm teaching a trans studies course. I've taught this many times before. I teach it more or less every year. And last week, I taught a document, a manifesto, called Transsexual and Transvestite Liberation, which was published in a gay newspaper, which was called The Gay Dealer, in 1969. So this document outlines 7 critical demands, and it was collaboratively authored by a coalition of 6 organizations of trans people, including the Triss Street Transvestite Action Revolutionaries, or STAR, the organization by and for unhoused trans people, founded by Sylvia Rivera and Marsha B. Johnson, who I'm assuming many of you are familiar with as historical figures. And this is not even to mention the fact that, as historians of medicine have so carefully detailed, gender identity clinics at major US universities had existed for decades by 1964. And I keep coming back to 1964 because this is the moment that Alito posits as being one in which it would have been unimaginable for gender identity or trans status to be something that people could have imagined as protected by law. So there's no question as to the historicity of trans and gender nonconforming people. My own work sort of shows this, even if people use different words in their own moment to describe this experience. So works by scholars like Susan Stryker, Jen Mannion, Jules Gill-Peterson, Kai Pyle, Colby Gordon, Riley Snorton, and many more makes this abundantly clear. This is truly a robust body of historical scholarship. And I'm not just talking about trans adults here. Indeed, as Jules Gill-Peterson lays out in her first book, which is called Histories of the Transgender Child. Anyone know that book? Yeah, there's a couple of people, I see a couple nods. There's a long-standing and very well-documented history stretching back to the very beginnings of the 20th century of trans children petitioning for what today we would call gender-affirming care. And this tradition is actually even older in Europe. So Magnus Hirschfeld, a doctor who began practicing in 19th century Germany, started seeing and treating patients he diagnosed as what he termed earnings. So this was a sort of word, a term of art created or like coined by sexologists at the end of the 19th century. It comes from the word uranism. So this is a diagnosis that to some degree combined homosexual sexual orientation with what today we'd call gender dysphoria. By the 19-teens, he had opened his Institute for Sexual Research in Berlin, which was also one of the first gender identity clinics to offer gender-affirming surgeries. And for what it's worth, that clinic was burned down by the National Socialists, by Nazis in Hitler's rise to power. The very classic photo that many of you may be familiar with of Nazi book burnings is actually a photo of the burning of Magnus Hirschfeld's library at the Institute of Sexual Research. So this is all just to say, even the most historically conservative accounts that would date trans healthcare, which would of course necessarily post-date the experience of trans people, as there would have been no need for trans medicine without trans patients. Even the most historically conservative accounts that would date trans healthcare to the second half of the 19th century. So putting trans healthcare somewhere in the neighborhood of 150 years old. So, however, if trans people and trans children in particular are hardly a new phenomenon, there's actually a facet of this moment of intense anti-trans backlash that is new, and that is the regulatory prohibitions on gender-affirming care. So before I begin, I want to remind everyone, and this is to reflect what Danny and Cynthia just reminded us of, I want to remind everyone that gender-affirming care for minors is overwhelmingly limited to therapy. Anti-trans backlash and polemicists like Abigail Schreier would have us believe that trans kids represent like 85% of all children worldwide, and all of them are currently waiting in line at cost-free gender clinics where surgeons are sharpening their scalpels, ready to cut out the ovaries and testes of unsuspecting youth. So this is not what's happening, just to be very, very, very clear here. And this is not what has been happening either. So in reality, gender-affirming medical care for minors is overwhelmingly limited to therapy. Hormone therapy was already inaccessible to most minors and is now more so due to gender-affirming care bans that are on the books or pending in more than 25 states. And gender-affirming surgical procedures are exceedingly rare to the point youth to the point of being practically non-existent. A 2024 article in the Journal of the American Medical Association, so JAMA, one of the foremost publications for medical research, reveals that in 2019, for example, no gender-affirming surgeries, and I repeat, 0 gender-affirming surgeries, were performed on any trans or gender nonconforming child under the age of 12. However, the article also reports a much higher incidence of gender-affirming healthcare for cis children, including things like nose jobs, breast reductions, and other plastic surgeries. So, think about that for a sec. So I argue that we should understand gender-affirming care bans as an expressive and highly ideological use of the law, insofar as they do not respond to real phenomena or events. And importantly, they fly in the face of a significant architecture of historical non-prohibitive regulation of gender-affirming care for both minors and adults. Consider that when gender identity clinics opened in the United States, and there's been many of them and they've existed for a long time, Johns Hopkins, UCLA, the University of Michigan, UCSF, and other locations, starting officially in the 1960s, many doctors who worked therein sought guidance from the attorneys general of their home states that the gender-affirming surgeries that they offered would not offend the criminal law, and specifically laws prohibiting mayhem or maiming. In 1949, for example, Harry Benjamin, probably one of the earliest and well-known doctors and most well-known doctors to offer gender-affirming care, including therapy, hormone treatment, and gender-affirming surgeries to trans people in the United States, he wrote with Alfred Kinsey a letter to the then state attorney Edmund Brown, who would later become the governor of California, asking about the legality of performing what were becoming standard surgeries, such as orchiectomies. The state's attorneys responded and importantly deferred to Brown's authority, not Brown, to Benjamin's authority as a doctor and a medical provider, declining to intervene. While gender-affirming care for both youth and adults has always been regulated in the way that other forms of healthcare are regulated, at least in the 20th century, with access being contingent on insurance, wealth, and family advocacy, which are often themselves shorthands for economic status, race, and age, there's not much of a history that anti-trans political antagonists can point to shore up efforts to specifically ban gender-affirming care for minors. Indeed, if anything, the law has been problematically enshrined, or the law has problematically enshrined gender-affirming care for a different set of minors under the umbrella of parental rights. And here I'm talking about children with intersex conditions who have been fighting in many cases for decades to codify legal protections against non-consensual surgical interventions recommended by doctors, too frequently accepted by parents, and wrought on the bodies of infants and toddlers, frequently to their significant physical detriment. So these interventions, I'm talking about interventions that are non-consensually imposed on the bodies of intersex kids or kids with intersex conditions. So hormone therapies, genital surgeries, including phalloplasties, vaginoplasties, orchiectomies, hysterectomies, and more, are really very clearly understood to be gender-affirming surgeries by doctors and parents seeking to align the bodies of their very young children with normative cis heterosexual gender conventions. So please note here first that I'm not trying to collapse the experience of children with intersex conditions into the experience of trans children. These are separate constituencies. And these are constituencies that are markedly distinct insofar as the former group, intersex kids, seeks to be free from non-consensual surgical interventions, while the latter, trans kids, seeks access to gender-affirming care in the face of contemporary prohibitions. But insofar as the architecture of medical treatments available to both constituencies developed together, so the first gender clinics treated very young children with intersex conditions, and the treatments developed in them became the basis for trans medicine as it exists today, I'd argue that what these historical phenomena describe is a history of not just legal non-intervention, but in fact the legal protection of gender-affirming care for minors. To begin to conclude, though, I want to sit with this strange tension wherein, on the one hand, the state enshrines protections for what it imagines to be gender-affirming care for very young children with intersex conditions, leaving their parents in charge of making decisions that will affect their bodies for the rest of their lives, despite the loud, long-standing, and very vocal objections of intersex adults. And on the other, the tsunami of prohibitions preventing access to gender-affirming care for trans, non-binary, and gender non-conforming identified children. These would seem to be polar opposite inclinations, right? Both enshrined in law, despite significant objection by the related adult constituencies, so intersex and trans adults, who are the most obvious immediate stakeholders in these regulations. So how do we read these together? How do we think of these together? So I want to conclude my remarks today with a proposition. I'm being a bit polemical, but I'm also not being entirely polemical here. So what if gender-affirming care bans are not entirely or even mostly about preventing the thriving of trans children and are at least partially a form of backlash to the increasing social and political power of minors more generally? So put another way, what if gender-affirming care bans, book bans, don't say gay laws, and the vast suite of other forms of anti-LGBTQIA legislations are each individual iterations of not only the homophobic, transphobic, transmisogynist, and broadly repressive energies of our own political moment, but also efforts to retrench and restore the totalizing legal subjugation of minors. When we look to these legislative efforts in relation to each other, so say we take Tennessee's gender-affirming care bans and we put them next to Florida's Don't Say Gay laws, which were, for what it's worth, slightly walked back, very, very, very slightly walked back this year. They look like they are laws. What we're gonna see is a vision of laws that seem like they're targeting LGBTQIA minors. But what if we line them up along a broader spectrum of both state and federal laws that seek to regulate and repress LGBTQIA minors, but that also target public school and university curricula and operations? So I'm thinking about anti-CRT laws, critical race theory laws, anti-DEI initiatives, the fair admissions decision, the banning of ethnic studies and African American studies in schools, the Biden administration's effort to regulate the participation of trans girls in K-12 sports, the repeal of mature minor statutes that allow youth access to vaccines and abortions, and more? What about the fact that one of the most powerful legal platforms being operationalized by the right now takes the form of demands for increased power and reach of parental rights, emblemized in organizations like Moms for Liberty, who, by the way, protested the last law school conference that I presented this work at. So when we think about anti-LGBTQIA legal and legislative movements in this light, we see something slightly different, and that's a broad ideological and legal bare-knuckle punch to the political power of minors. Now, one objection to this, what I'm sort of polemically suggesting here, might be to say in response, or ask in response, well, what political powers, right? Minors don't have political power. And, legally in the United States, to some degree, that is broadly true, right? So within the citizenry, minors are probably one of the most categorically disenfranchised groups in both a literal and figurative sense, in terms of being cross-sections of the population, as minors or minority status cuts across all racial, ethnic, socioeconomic, regional, citizen and immigrant, and gendered and sexed populations. But think about youth movements over the last 20 years. Think about youth movements over the past 60 years. Think about anti-war movements. Think about Greta Thunberg and climate protest walkouts that we saw in our public schools. Think about critiques of boomers. Think about student movements of this past spring. Think about so-called cancel culture and what's enabled youth on social media to what this has enabled youth on social media to do in terms of operationalizing protest. Think about how access to the internet more generally has enabled minors to vocalize political dissent and amplify their voices. I've asked myself time and time again over these last few years whether we are in a de facto moment of renewal around what in the 70s was called children's liberation. And if some of the anti-queer and anti-trans legislation and legislative organizing that we're seeing right now is backlash responding to just one facet of that work. It's almost banal these days to say that young people drive political change. It's a commonplace amongst the political maxims that older adults offer youth. People said this to me when I was a kid. So what I'll offer today by way of a concluding question is this: what would it mean to suggest that children and minors often, but not always, need protection, but that the political power of children and minors always does? Thank you. Oh, sorry.
Oh, can we put up my slide? Okay, thanks. All right. Hi, everyone. My name is Joe Wardensky. I'm going to bring the more of a litigator's perspective to this conversation. As Greg said in my intro, I 3 years ago founded my own civil rights law firm in New York, where the bulk of my practice is on trans rights and LGBTQ rights issues, particularly trans students and trans health related litigation. One of my current cases is suing the Elkhorn School District in Wisconsin on behalf of a 13-year-old trans girl who, despite Seventh Circuit precedent that I created in another case, are ignoring the controlling case law in that jurisdiction, like a lot of other school districts are, and responding to the Moms for Liberties of Wisconsin and denying trans kids the right to use bathrooms and otherwise not respecting their identity. So in our case, we got an injunction in August for our client who just started 8th grade, but the case isn't over yet, and it's one of many cases around the country that are seeking to, firm up in places where those protections already exist, these protections, and to push back against the sort of contrary movement that we're seeing in the Title IX space with regard to the challenges to the Department of Education's regulations and bad case law and other federal courts around the country. So today I want to just provide some quick overview of some sort of data points about what LGBTQ and particularly trans students are facing in this political climate, and then talk more about the sort of evolution of federal protections for trans students over the last maybe 15 years, which has been a story of really positive change for a while, incremental but good. I would say landmark changes for maybe the first 10 years of the last 15, and then retrenchment and opposition that we did not see in those first in that first part of the period, where it seemed like things were just going well, and that there was a general recognition that LGBTQ kids exist and that the rights that they have rights and they should be protected under Title IX and other federal laws. And then the right wing kind of woke up and realized this was an effective political issue, along with the anti-critical race theory efforts and the other anti-public education efforts, right, to make any students of any sort of minoritized status and everyone else feel like going to school is just untenable, right? And I think it's part of this larger project on attacking anyone who's of a minoritized identity, but also attacking public education, where so much of these issues come to play. So the Movement Advancement Project is an organization that creates what's called these equality maps on a host of issues. And if you're interested or are doing research, they're updated constantly on a host of discrimination issues facing LGBTQ people. And I found them to be an incredible resource as someone who cares about these issues, but also as a litigator and helping to educate courts about how widespread the need is for concrete protections and the level of discrimination that trans kids especially are facing across the country. So you'll see here that less than half the states have affirmative state-level non-discrimination protections. The probably majority of states have no protections one way or the other, and that we're seeing a growing number of states where they're passing laws, especially in the last just 2 or 3 years, that are going from a sort of neutral, there are no protections, but we're also to an oppositional structure where these protections are being taken away affirmatively in response, I think, to this sort of hysteria, like Professor LaFleur was saying, that this is a new issue, that this is something that didn't exist before, right? And nothing about that is true. I think because they're, at least in part because of the advancement of legal protections and society generally, that more people came out and felt comfortable coming out earlier, and that's being perceived as a change, as opposed to, so many people, like gay people and lesbian people before, the trans kids and non-binary kids are now feeling more comfortable about coming out, but in response are facing sort of a blowback, particularly from conservatives who are seeing this as a easy political tool, probably more than anything else. So this map shows the landscape for affirmative restrictions on students' restroom and locker room use at the state level. Most states do not have affirmative restrictions, but the number of states that do has grown quite substantially in the last couple of years. It's especially true in the athletics context. This map is from this summer, and you can see how many states have now imposed restrictions on trans students playing school sports that are consistent with their lived sex. This map, if you pull up from just 3 or 4 years ago, had 1 state on it, Idaho, just a couple years ago. And so you can see that this is not, sort of an organic, effort at discrimination, that these are, concrete, planned, a right-wing attack on students' rights that are, drafting model legislation, implementing it through these very conservative legislatures, and, taking rights away at the state level, right? And the countervailing balance, and what I want to talk about, is federal protections, which are available in some places more than others, but are not yet a reliable source of protection for all LGBTQ kids. And I think it's very difficult to predict where things are going to go over the next few years, given the Supreme Court that we have, which doesn't give any of us, I think, a lot of optimism about any sort of expansion of rights. policies requiring schools to out trans kids to their parents. Those laws have also increased in the last few years in many, many individual school districts. So the main federal protection, there's obviously no federal law that prohibits sexual orientation or gender identity discrimination per se, and there have been legislative efforts over the years that have not yet come to fruition. The Student Non-Discrimination Act that may in a friendlier legislative and presidential landscape someday pass, but currently we don't have federal protections in any context that prohibit sexual orientation and gender identity discrimination. But what we do have is laws that prohibit discrimination on the basis of sex. And those laws, including Title VII in the employment context, Title IX in the schools context, the Fair Housing Act, the Equal Credit Opportunity Act in the sort of credit and lending context, and others, have been used to enforce, to challenge discrimination, discriminatory practices, and harassment and discriminatory treatment by trans and other LGBTQ people under the theory that the principle that these are forms of sex-based discrimination. In 2020, the Supreme Court, in a 6-3 decision, and that 6-3 included Chief Justice Roberts, Justice Gorsuch, who wrote the opinion, and Justice Ginsburg. So already we've lost, Justice Ginsburg. So this count would more likely be 5-4 at best, in this particular case. The Supreme Court held that under Title VII, the employment discrimination law, that discrimination on the basis of sex necessarily includes discrimination based on gender identity and sexual orientation. And in that case, it was several cases that were combined for the Supreme Court. All of the plaintiffs had been fired for being trans or gay. And so Justice Gorsuch, in his opinion, held that to fire someone merely for being, and his words, not mine, homosexual or transgender, is a form of sex discrimination because you can't take sex out of the equation. That you're looking, to be gay, to be trans, you're necessarily taking sex-related considerations into account because, and so the Supreme Court held that at least in the employment context, you can't separate from, on a textual level, the discrimination based on sexual orientation, gender identity from sex discrimination. Justice Alito had a heart attack in his dissent. Sort of trotted out the parade of horribles, and he even had appendices to this dissenting opinion that said, this analysis is outrageous. If this follows through to its logical conclusion, then all of these federal laws, and he had an appendix that had 100 or more, different federal laws that prohibit sex discrimination, will have to be interpreted to protect LGBTQ people. He obviously thought that was a horrible outcome. I think that is the correct outcome and the proper reading of the law. And so if Justice Alito were to follow his own guidance, he would feel, compelled now to hold that, discrimination under Title IX, under the Fair Housing Act, under these other laws, necessarily protects LGBTQ people, and lots of lower courts have correctly already, found that. Others are taking advantage of this line in Justice Gorsuch's majority opinion that said this case is only about firing, and we're not prejudging, how this principle will apply under other statutes or to bathrooms or, all these other things, all the other types of discrimination. I think that was a true, true as far as it went, right? Those cases presented employment discrimination that included firing, right? And so it's not unusual for courts to say, we're not prejudging facts, not in front of us. But it was also clever and I think a little dishonest to say that as a matter of statutory interpretation, discrimination on the basis of sex necessarily includes discrimination on the basis of sexual orientation and gender identity. But I'm not going to tell you what that means in every other statute that says discrimination on the basis of sex is prohibited, right? I think he was trying to, have his cake and eat it too, and also leave the door open for more conservative opinions down the line, which conservative judges in lower courts now have taken advantage of, saying, well, that case was only about firing, and so we can completely restart the analysis and use the old sort of rejected analysis under Title IX and under these other laws to say that those rights don't exist. I think that's wrong, but that's where we are. But Bostock didn't create the right. And for almost 20 years before Bostock was decided, federal courts had already found in employment and schools cases that trans people were protected from discrimination under federal law. There have been a whole host of cases in the 70s and 80s that found that trans plaintiffs who were trying to use Title VII, who have been fired or denied employment, could not use those laws, that they didn't reach as far as what they then called transsexual status usually. But in 1989, the Supreme Court in the Price Waterhouse versus Hopkins case held that discrimination on the basis of sex is not just discrimination for being a man or being a woman, right? That it can also include discrimination based on sex stereotypes. And so the plaintiff in that case was a cis woman, an executive at Price Waterhouse, whose male colleagues thought she was, too ambitious and too butch for the job, and so she was denied a promotion to partnership, right? She didn't conform to female stereotypes of, instead she was masculine in the sense of trying to sort of fit in as an executive in the 80s at a Big Five accounting firm, and instead she was fired for that because she was insufficiently feminine, right? But the court announced this principle that sex stereotyping, not just what sex you are, right, or what gender you identify as, but how you present your gender and how people perceive how you present your gender can all be bases for legal protections. And so based on Price Waterhouse, in around the year 2000, there were two courts of appeals, the First Circuit and Ninth Circuit, that held that trans plaintiffs under a sort of sex stereotyping theory for not conforming to stereotypes of essentially their sex assigned at birth were protected under federal law. In the Ninth Circuit, it was the Gender Motivated Violence Act, which incorporated the Title VII analysis. The First Circuit was a lending case, a trans or gender nonconforming female presenting woman showed up to apply for a loan at a bank and she was denied. And then in the years that followed, in 2004, 2005, the Sixth Circuit issued Title VII cases holding that trans people were protected under a sex stereotyping theory, right? It didn't go all the way to say that, being discrimination for someone for being transgender per se is a form of sex discrimination, but if you can sort of frame it as a nonconformity to sex stereotypes, that that will work, and it often works in cases involving harassment, right? That if your colleagues or your fellow students, your classmates or your teachers are harassing you, bullying you for nonconforming to gender stereotypes, that can be true for trans kids, it can be true for non-binary kids, it can be true for just kids who don't conform to gender stereotypes. And so that's where the federal protection started to really kick in. And I worked at DOJ in the Educational Opportunities section in the Civil Rights Division for 6 years, from 2010 to the very end of 2015. And during that time, DOJ and the Office for Civil Rights at the Department of Education were working together to more robustly enforce Title IX protections on behalf of LGBTQ kids. So one of the first cases I had was a case involving a tragic suicide of an 8th grade student, Seth Walsh, in Tehachapi, California. Tehachapi is pretty rural in Kern County, probably the most conservative county in California, and he was gay by the time he got to middle school, but he had been harassed for years, not just for being gay, but also because he wasn't conforming to gender stereotypes. And the school knew about it. The school not only did nothing about it, but I would say made it worse by their response. And so in 2011, there was an out-of-court settlement agreement. That was the first, I believe, enforcement action that the federal government had taken under Title IX for an openly gay student. The next year, we investigated a case also in California involving a trans 8th grade student who wanted to use the boys' bathrooms and otherwise be treated as a boy because he was a boy and had been a boy and had always been a boy. And they were, it was Arcadia, California, a pretty wealthy suburb of LA, but they were still like, we're not sure, and we're not gonna do that. You're gonna have to use other facilities. So. With that, the DOJ and OCR enforced Title IX on behalf of a trans kid. And then that set a process where the agencies decided to issue guidance in 2016 to all schools to say, to comply with Title IX, you should not discriminate against trans kids. You should treat them like the sex that they know themselves to be. That was shot down by a federal court, and then not appealed because the Trump administration took over. There have been now, many other cases, including the Whitaker case in the Seventh Circuit that I had the benefit of arguing when I was in private practice, and that have established that to discriminate against a trans kid in restroom access or other ways violates Title IX. But you've now had federal courts going the opposite way. The Biden administration trying very hard to, codify some of these statutory principles into regulations, and then federal courts, stomping on those almost immediately, right? And so it's this push and pull, I think it. I'll stop here and answer more questions, but I think we don't know where the story is going to end. But in the absence of state level protections and the sort of onslaught of like affirmatively bad things at the state level, the need for federal protections is and for lawyers to be litigating these cases, even if only in the friendlier jurisdictions, to sort of firm up the case law, is as important as ever.
Good afternoon. Cynthia Weaver, she, her pronouns. Thanks for having me. I'm also a litigator by training and HRC as well, but I do some of the policy work with our legislative folks. And I'm a movement attorney, for lack of a better term, in that we coordinate with the other legal nonprofits, organizations to strategize how we bring cases, how we argue claims. We also work with folks like Joe in the private bar as well to strategize. So I'll bring a little bit of a gloss, if you will, in terms of the, at a high level, some of the arguments and disagreements we've been talking about and where we land. But also an overview of the legal landscape legislatively and in the litigation, and all this boiling down to what I think really is just a way of changing who we are, right? Social change efforts, conversion therapy, and all of that. Let's see here. Am I doing this right?
Yep.
Oh.
Just the arrow. Oh, there you go.
Oh, okay. There we go. So, Joe mentioned, and Greta also mentioned, like the last several years, an increase in anti-equality bills being introduced. And every year we keep saying, oh, it's the worst year, it's the worst year. And finally we're like, okay, no one's paying attention to us except for us. We're tired of it. There was some complications around whether we should or should not do this, but HRC issued a national state of emergency. We put together a guidebook for families and others in terms of how to travel to other states or stay in your states if you cannot travel and leave. It's been 1 year, one legislative session. The number of bills being introduced dropped a little bit. There's some differences, but it's really because there's now focus on the current cases percolating up to the Supreme Court, and some states are kind of waiting to see what's going to happen with equal protection claim arguments, Title IX, that sort of thing. And there are many different buckets of laws being introduced. You've heard them today already: bathroom, forced outings, athletics, curriculum bans. And what do they do, right? What do? They attack every facet of a support system that a child needs, whether you are LGBTQ plus or not. Trends come in waves. Bathroom bans and athletic bans were, the hot topics, and then there was a slowdown on healthcare bans. And then now, because there have been so many bans already in that space, other states are coming back with athletic bans. And although most bills don't get don't become law, the ones that do are quite harmful. One thing that is kind of new is the erasure laws, is the attempt to redefine the word sex in their state code, right? So do a search and find in your state code, where is the word sex? And then they define it as a non-binary concept. That is a way to erase trans people, other folks out of the laws in terms of protections and other things. And I want to talk a little bit about just Bostock. We all have many feelings about it. I remember the day that when the decision came out. It was the middle of the pandemic. Like, I was sitting, at home working on the situation where the Samaritan's Purse wanted to set up a field hospital outside one of our main hospitals in New York City. And then this came out, and I was like totally shocked. It was from Gorsuch, textualist reading, right? He made it very clear that this is just about Title VII. And Joe talked about firing, because the three plaintiffs these were employment termination cases. What is happening now? The EEOC issued workplace harassment guidance for the first time in like 25 years, basically saying you cannot harass people based on SOGI characteristics. And now they're being challenged. They are arguing that Title VII has to do with firing under, Bostock has to do with firing under Title VII and not harassment. It is a relitigation of Bostock. It is Bostock 2.0. It's not getting a lot of traction. I'm not entirely sure why, other than the fact that Scrimeti is before the Supreme Court. But I wanted to flag that for folks, because our rights under Title VII it's still not clear after Bostock. And after Bostock came down, Biden came to office, he issued an executive order directing certain agencies to interpret their enforcement powers in accordance with Bostock. So these laws, and Joe also mentioned them as well, right? These laws that we're trying to invoke for protections, he had ordered the agencies to actually come together with a more formal plan in terms of their enforcement mechanisms. And all of this would be unnecessary if the Equality Act is passed. The Equality Act amends the Civil Rights Act and other acts, basically to define sex to include SOGI, right? We've been trying to, the entire movement has been trying to, get this passed for many, many years now. We couldn't get a vote, but just pressing on the point of the importance of getting this passed, we will have to have this patchwork of protections at the state level. And I wanted to now go to this video of some of the parents in our national council. Do I push something? Do you, Brian, do?
I think.
Do I press it?
It seems that this attack, coming up like to an election season, is trying to stir up those feelings of bigotry, trying to stir up to us those feelings of hatred, against a group, you know what I mean, a demographic that's an easy target that a lot of people still don't understand, have a frame of reference for, can combat mistruths, misinformation, and lies, just outright lies about. And so it kind of feels like a group that you have to protect with the truth of what it is. And my son, he follows it. And sometimes we'll see him in the morning and he's like, what's going on, kiddo? He's like, he just saw something new news about his community and his heart, but getting him to understand that some people in this country are going after the low-hanging fruit to stir up bigotry and hatred, and see it as that, and that's how we're going to fight it.
I was going to piggyback, because when you said how he's coming home, so he's at that age where social media and you're seeing things. So as he's trying to develop his self-confidence going out into the world, making that next step of, thinking about college and his future, having this moment that we're having in our country's history is like, it feels so personal to him. They hate me. They don't want me to exist. And having to explain to your child as they're trying to grow into their confidence of who they are as a person, and having the wherewithal to deal with all of that and still feel like you're somebody and that you deserve a future where you can see into it and see all of this success for yourself and all this viable outcomes of wonderful ideas that you have for your future. And it feels like we're combating that all the time, trying to get him to understand that, it's not that everybody hates you, and it's not that, everybody's against you. And that's work, and it's scary as we're trying to have that space that our kid needs to grow into himself and to feel confident about himself and his role in the world.
So we live in a state that has the usual lineup of bills. So the sports bill, the parental rights bill, the gender affirming care ban bill. I'm sure there's, the Department of Education, with curriculum bans and all kinds of things. And so we've had to develop a backup plan. Because our child gets, gender affirming care, including the medically necessary evidence-based hormones, we have had to talk with families who live out of state and say, here's our plan in the event that this all gets shut down in our state. We've already talked about who's staying, who's going, what's going to be the impact to our job, what's going to be the impact to our family. And it is so scary and frustrating because we feel like so much of our life is on pause while we wait to see what happens.
Mm-hmm. Yeah, it's that, I agree. We sort of feel like we're not in control of our own life right now. And being Jewish, this feels very familiar. And my husband has always said, there were people that did not leave Germany in time because it was too late. And I don't want us to get to the point where it's too late. I live in Georgia and watching Florida, where now, kids it's legal for the state to take a child away during custody battles. And what's the next thing from that happening? And can it affect us? And what are we going to do? And where are we going to go? And thank God we have the resources to get out. But there is a part of me that is afraid that we are going to wait 1 minute too late.
Like Jennifer said, this has happened before. There is precedent for what's happening. If you go back in the history of this country, after, emancipation, you had this literal migration of people away from the South because the South was not a safe place to live. You could be a free man and picked up and put right back in slavery. And we're talking about the home of the free, the land of the brave, where you should not have to think about being a refugee, as Mike said. There is simply nothing American about what's happening, and yet it's so American what's happening. Leaving your state to go to another state in the borders of this country is simply not acceptable. We should not accept it. People who are not impacted by this, who do not have transgender, non-binary, gender non-conforming kids, should not be sitting back thinking, oh, well, it doesn't affect, it affects us all. This affects every single last one of us. If one of us is not free, none of us are free.
It seems that this attack, coming up.
Okay. So I'm going to try to breeze through the rest of my presentation. I know we're running up in time, but I show that video, right? Parental voices. They are not going to be heard before the Supreme Court in this committee. And it's really important for me that you hear from them. Like it's more important that you hear from them and not us, right? The original case, LOW v. Scammetti, brought by ACLU and Lambda Legal on behalf of 3 trans kiddos. They got a preliminary injunction in lower court, went to the Sixth Circuit, and in like a scathing, like horrendous decision, they reversed it, and now it's going to the, before the Supreme Court. The DOJ had intervened at a lower court level on behalf of the United States as a plaintiff. SCOTUS took their petition and not the family's petition. And so that is, I just want to point it out, I was very angry when that happened. I mean, I was very, very angry, maybe more so than some of my colleagues, because now it seems like it's a politicized case, where before we had like real people who were impacted, like with a face, with a name. But the Solicitor General had filed a motion to divide up some of her time with ACLU so that some of this can be heard by the bench on the equal protection claim, not the substantive process parental decision-making claim. And one kind of tie-in I wanted to put in with Bostock is, even though the claims are very different, the issues are very different, Gorsuch is a historian, and I hope he sticks to that and recognizes that at least factually, he'll recognize that as he reads these briefs, reads the amicus briefs, and hear the arguments. And in that vein, maybe he will be able to persuade some of his colleagues in the legal analysis. But that's the one point I wanted just to tie with Bostock in the Scammetti case. And all of this, to me, these bans are efforts to change one's gender identity, and Greta kind of talked a little bit about that, right? It's not the type of conversion therapy that we see. We think about it as speech-based talk therapy, and back in the day, it was had a more physical component to that type of therapy. But if you don't allow someone to be who they are, that's an effort to change your gender identity. And we haven't really talked about it in this way with these bans, but that's what it is doing. Skip through some of the details, but I wanted to tell folks that there's a circuit split on conversion therapy. Otto out of Florida, 11th Circuit, Tingley out of Washington State, 9th Circuit. Basically, 11th Circuit says this speech-based therapy is not medical conduct, but it is expression of viewpoint, and regulation of that is presumptively unconstitutional. The 9th Circuit found the other way. It was appealed to the Supreme Court by cert, and they didn't take it. So now there is a clear split. It's very recent. The case, like Otto, just closed this summer as well. These claims are First Amendment speech issues, free exercise, some 14th Amendment vagueness claims, invocation of patient's Bill of Rights for a patient to receive information about, to be converted. That's their argument. And the basis for these bans, right, is the fact that there are many studies out there, actually one came out on Monday in The Lancet, that this type of approach, therapy, it is ineffective, it is harmful. It results in a host of adverse mental health outcomes for people. I think the report is like 4 to 34% of adults surveyed between 18 to 84 have experienced some type of conversion therapy in their lives. It's not grounded in medical science, and by providing this care, that is a type of fraud, and that is the basis for some of these bans. Good bans for us. And I'll just go through it real quick, but gender affirming care, conversion therapy, all these ideas are all interconnected and connected globally. The anti-gender affirming care rhetoric is exported to the US from the United Kingdom. And there has been some voices in the international space to support our protections. And in 2020, the UN independent expert on social matters talked about how conversion therapy goes hand in hand with laws that criminalize same-sex conduct, right? Lawrence for P. Texas and others. And going back to this chart real quick, you see, like, in 2020, once the UN kind of issued something a little bit more formal and the General Assembly called for it end, there is an increase on the type of bans, country by country. So I'm going to indulge me. It's a 30-second video. I just want to play this for y'all. It's 30 seconds. Thank you, Brian.
Won't you leave it at the door?
Hey Dad, do you think you could teach me how to shave these off?
I think that speaks for itself, and I'm so in awe of the parents we work with. I wish I had parents that support when I was a career kid. So, thank you for your time.
Hey everyone. So it's going to come up in a second, but I'm going to be speaking on advocating for LGBTQ plus system-involved youth, and so I focus on policy. I used to represent young folks in family court, in child welfare and juvenile justice proceedings. You can skip over. I don't know how this thing works. So, and you'll have a copy of the presentation. I have, some of the sources from some of the poll questions we went over earlier, but I do like to start. I know we've shown a lot of videos, but I do think it's important, especially when you don't have enough folks with lived experience, that their voices get, to be heard in the space. And so I come to this work as an individual that went through the child welfare system myself and was openly LGBTQ in New York, and I can talk, a whole presentation for 2 hours just about that. But I think it's important for us to understand that the experiences of young folks in foster care, even when they're not LGBTQ, are awful, right? On average, in general. If they're in a placement where they're, supported, even non-LGBTQ young folks, that's like a dime a dozen, right? Most often than not, it's stressful. It's increased trauma that they've already had, or sometimes added trauma that they may not have had. And so it's important to kind of have that perspective. So, and when you think about that, especially for youth of color, LGBTQ plus youth, they have some of the worst outcomes in the system and some of the worst times in the system. So I want to show some of the video. I may ask them to stop it partway through, but you'll have it in your materials to finish. So if we can go to the first clip.
I identify as a trans male. I identify as pansexual.
I identify as gender fluid, and I use they, them pronouns.
I identify as bisexual. I identify as a transgender male, also gay and foster youth.
A lot of foster homes just won't accept LGBT youth.
You never know, is this family gonna accept me? Are they gonna be okay with me being transgender, gender fluid?
I was like, okay, well then, where is my home? Where do I belong?
I mean, I think it's just really important to understand how brutally some of these kids have been treated when they started to try and express themselves when they were younger, and how much that stays.
It's been hard not to compare myself to other people.
I was depressed, I was lonely, I was hopeless, I felt like nothing. To me, it's amazing.
It's felt like a safe haven for me. After so many years of hiding and being cautious, I finally get to actually express who I want to be.
It feels like I'm at home, I'm free to be who I want to be.
identify as a
There's, a few different statistics. A lot of folks may have heard of, like, some of the stats say 40% of youth in runaway homeless youth systems identify as LGBTQ. Some stats say LGBT youth represent 29% and trans youth represent 4%. Regardless of the variances, close to half, or at least a third, of young folks in the runaway homeless youth system identify as LGBTQ, right? And there's a number of reasons why that is. Some of them have also touched the child welfare system a lot of the times before they enter the runaway homeless youth system. Family acceptance, societal issues, poverty, things like that. There's a number of factors there, and it's very similar to the reason why we see this overrepresentation of young folks in foster care that we mentioned in the poll earlier. But what I want to emphasize is that most of these young folks are youth of color. In the foster care system, about 60% of the LGBTQ youth in the system are youth of color. I will mention this disparity, though you can have like a whole training on it. Young folks who are system involved oftentimes are over-medicated and over-diagnosed. And so the range 13 to 52%, that's because depending on your state, where you land there, of foster youth have some sort of psychotropic medication prescribed to them. And that's in comparison of only 4% of youth who are not involved of the system having some sort of psychotropic medication prescribed. And, in the US, 1 in 9 Black youth and 1 in 20 Latinx youth would have an incarcerated parent. And, oftentimes this may not be the exact reason why they enter the system, but a lot of times if it's not the reason they enter the system, it's the reason why the family separation continues, right? And the lack of coordination and working with incarcerated parents so that when they are released, that they can get their child. And I'll tell you, as someone who, practice in trial court, oftentimes they were not involved. They were not given proper notice at times. When they were involved, technology issues, they can't, be here, or they're told of the wrong date, or when they do participate, it's, very underwhelming and not the same as if they were present in the room. In terms of, just the disparities that continue to exist, even though, I left the child welfare system in 2009, was in it from 2001 to 2009, there's been a lot of changes in the system, right? There's been a lot of reforms across the country, but still the disparities persist that Black and Native youth overly enter these systems, even despite the changes that have made. And so half of Black and Native youth would at some point in their lives encounter the child welfare system. And so that may not mean that they were removed from their families, even though they do have higher rates of removal than every other set of youth, but it does mean that they would have had an interaction where someone's coming to their home and the threat of removal is there. And so I'm going to go a little bit, and you'll have the slides to go in more detail, but this is just to put it on folks' radar that HHS recently introduced the designated placements rule. And back in November 2023, NCLR gave comment. The rule at the time had a different name. It was called the Safe and Appropriate Placements Rule. And really what that rule, and even with the name change, what it's trying to get at is addressing, placements for LGBTQ youth, because there's so much feedback for decades that, they're not having good experiences, overly placed in congregate care and residential settings, more changes in placement than other young folks. And so this rule is effective as of July 2024, but agencies, and this is a national, this is the rule nationally. So across the country, agencies by October 1st, 2026, have to make sure that they are implementing the provisions of this rule. Unfortunately, there are some religious, carve-outs, so how things will play out state by state, even within the same state, because a lot of foster care agencies are connected to some sort of, religious base, will be different, but, this is what the law is, right? And so they're going to have to, even if they're religious-based, going to have to request, to try to get an exemption, from certain aspects of this rule. And even if they do, if a young person is LGBTQ and they want to utilize this rule, something has to still be figured out. If that means on the state level that they may have to change agencies, which happens frequently anyway in the child welfare system at times, but that young person still has the right to have access to that rule. It just does not require certain agencies to who are religious based to have to implement certain provisions of it, or certain foster parents, who might be religious. There's aspects of it where they can't be forced, but that doesn't mean that LGBTQ young folks, even if they're in those agencies, can't utilize this rule. And so that's, why there's such a long time period to try to figure out how this is going to happen. And so I'm putting it on people's radars because, even as students, you may be practicing in a year or two where, this law is directly going to have a shape on like the experience of young folks in the child welfare system. And so the main aspect of the rule is that a young person is going to get to make a request to have a safe designated placement. And what that, means is that they're going to have to make sure that the provider meets certain standards, and that would mean that they are, trained in knowing the skills and needs, related to LGBTQ youth, but then also to make sure that the environment is supportive of them as well. And they have to make sure that information is provided in an age-appropriate way. So we talked about the different age ranges. They can't say, oh, well, we're only informing older young folks. We don't have any age range. They have to make sure they break it down. And the next slide goes into the age range. So if they're 14 and over, they automatically have to be aware of this rule and given notice of it. If they're under 14, they still can get notice of it if they have certain circumstances that the agencies, the foster care agencies and the child welfare agencies are aware of. And that would be if they were removed from their home due to some, familial conflict regarding their sexual orientation, gender identity, in whole or part. So it doesn't have to be what the case was about, but if they're aware that that's related to partly why they're not at home, then they have to give them notice of this rule regardless of their age. And if they've disclosed their LGBTQI status to a caseworker, child welfare agency, someone that's involved in the agency, anyone who's involved in the agency, if it's disclosed, then they have to make them aware of this, regardless of what their age is. And again, the notice has to be, age appropriate. And they also have to let them know the non-retaliation protections, which I'll mention in a second. And then in terms of placement decisions, they really have to give weight to a young person's, expressed concerns and taking into, account best, interests. And these were things that we specifically commented on because we wanted to make sure that if a young person wanted to stay in a home and try to work with the foster parent because they built that connection, that they weren't just up and moved because they said there's like a conflict here and them not, being affirmed in the placement, and that they, gave strong weight to what the child wanted. And they have to make sure they have a process in place to report if there's any issues or concerns in their placement, if safety concerns, if they're having problems in their placement due to their LGBTQ status. And in terms of retaliation, there has to be a procedure that the agency and any, provider entities, so, they use a lot of contract agencies and third parties a lot of times in the child welfare system, anyone acting on behalf of the child welfare entity. So anyone that they are contracting to work with young folks, they have to make sure that that provider does not retaliate against a child based on their LGBTQ status. And there's a number of, carved out protections, and some of it brings up some of the things that we mentioned. That includes that they can't be harassed or mistreated or abused. They can't engage in like conversion therapy, to undermine them. And then also, in terms of like disclosing the young child's status in ways that would like cause them harm, and also using their status to like sustain a child welfare protection investigation. And we know some, states have, tried to issue laws in that regard, and they can't take actions against like a supportive caregiver or caretaker. And so there's a lot of other provisions of the rule, but I wanted to make sure that folks were aware of that. And then in terms of this clip, we'll skip over that. for timing, but I do encourage folks to look at it. It's a clip of folks that identify as transgender that are in a housing unit in jail in San Francisco that are young adult age, and just talks about some of their experiences. The next slide I want to go into, and I know we're getting over time, but I want to, emphasize that, like I mentioned during the poll questions, LGBTQs are overly represented in the juvenile justice system. But again, emphasizing when we think about this and think about race, 85% of the youth that are in the juvenile justice system that are LGBTQ are also youth of color. And as I mentioned before, LGBT girls, about 39.4% of them are in some sort of juvenile justice facility as compared to their LGBT boy peers at a significant rate. And so, when you think about racism, sexism, homophobia, how all these things interplay, we can't talk about LGBTQ young folks in these systems and not talk about those things as well. And so in terms of our juvenile justice advocacy, we, in 2022, worked in a coalition with folks with lived experience and legal advocates to get the California Youth Bill of Rights passed. And this is a bill that now every young person who's incarcerated in California must be made aware of this upon intake and must be put up as a notice in the facilities. And they're also given that information on their right to report to the ombudsman if there's any violations. I'm just pulling out some of the key areas here in this provision. They have to make sure that clothing, grooming, hygiene products, that are culturally, appropriate, and then also take into account their gender identity and expression. And then in terms of, safety, that they don't discriminate against them based on their gender identity, sexual orientation, and that they have to have the same access to services, so housing, care, placement. And the video that I was going to show showed that, that particular unit separated, trans folks, and they were crammed in this little kind of petri dish area. And even though they built community, right, they talked about not having access to the same things, not being able to go outside during the same amount of time as other folks, not being able to get certain services because there wasn't space in the area where they were held to receive those services. And so, the importance of this bill and laying out that they should not be treated differently, and that's in addition, to race and religion, but also sex, sexual orientation, gender identity, and expression. Yeah. So just, to give folks just an understanding, when you're working with system-involved youth especially, making sure that that any, healthcare needs that they might have, housing needs, non-discrimination, a lot of times working as attorneys, and even if you get to, intern with someone, it's important that, you keep certain things on your radar. Are they getting access to gender-affirming care, clothing? Do they have an option on where they want to be housed? These are all really important measures. And the next slide is just a list of some of the public education and coalition work that NCLR is engaged in. And I wanted to make sure that folks had resources. So you'll have that in your materials as well if you want to know a little bit more about just how to support LGBTQ youth in general. And also if there's any issues, we have a legal helpline that's up on the screen here. Thank you.
Because every time I use this, oh, it's on today. That's fantastic. I just want to say thank you again to our wonderful panelists. That was absolutely fantastic. Thank you. We sadly have run out of time for Q&A. However, I encourage everyone to head over to Barristers. That is a way more intimate setting in order to discuss with our fantastic panelists. As usual, if anyone is able to help hands with cleaning up little bits and pieces, that is always fantastic. I will be here. And that concludes the third week of Symposium. I can't thank you guys enough. This has been absolutely fantastic, and this has been actually our first in-person panel since the pandemic, the Symposium, and I wish Charlotte was here again to thank her and all the fantastic work that she has done. But thank you.
Thank you. I have some NCLR swag if folks want to like make my bag lighter going home. It's right up in the front. Oh, yeah.
It's better than the others.